Hello, my name is FLOR SALVADOR. I'm an attorney with Legal Services of Northern Virginia, and I'm here to give you a brief update on tenant and housing laws related to COVID-19 as of May 27, 2020. First, tenants' rights. Usually in Virginia, when a tenant is late in paying rent, the landlord must give the tenant a 5-day pay or quit notice before proceeding with an eviction in court that's called an unlawful detainer. This notice typically gives the tenant 5 days to pay rent. However, under a new federal law called the CARES Act, a 30 days notice is required instead of 5 days. This law also forbids a landlord from filing an unlawful detainer for 60 days starting from March 27th or charging late fees during that time, and only until that time has expired can the landlord issue the 30 days notice. This is good for tenants because it gives them more time to pay rent and stay on the property. But in order for this law to apply, a few conditions must be met. Tenant must live on a property that has either a federally backed mortgage or participates in a rural housing voucher program, or another federal program such as the Section 8 voucher program or low-income housing tax credit, and the landlord hasn't already filed an unlawful detainer before March 27th. However, if this federal law doesn't apply to you and you haven't paid rent due to the coronavirus loss of income, Virginia passed a new law allowing you to continue an unlawful detainer case that's been filed against you for a number of 60 days. This law applies to tenants who aren't receiving income due to the governor's state of emergency, which started on March 12th, and federal employees who've been furloughed due to the closure of the U.S. government. If an unlawful detainer is filed against you and you fit this criteria, you can ask for a 60-day continuance by showing up at the first court date and showing proof. For a tenant, this means a pay stub showing $0, a copy of a furlough notification letter, or any other documentation deemed appropriate by a court. But again, in order to take advantage of this, you must show written proof to the court on the initial court date. Foreclosures. Recently, mortgages insured by Fannie Mae, Freddie Mac, FHA, Veterans Administration, or USDA announced that they were extending their practice of suspending foreclosures through June 30th, 2020. Additionally, under federal law, if you have one of these federally backed mortgages on a single-family home and have experienced a coronavirus-related financial hardship, you can request a forbearance for 180 days and request an extension of another 180 days. During the forbearance, the servicer cannot charge you additional late fees or penalties. If federal law, however, doesn't apply to you and you've experienced a loss of income due to the governor's state of emergency and you've defaulted on your mortgage, under Virginia law, you can request a 30-day suspension of a foreclosure proceeding by providing written proof of loss of income to your servicer. I know this was a lot of information and it was very abbreviated, but I hope it was helpful. If you're seeking specific legal advice about your situation, feel free to apply for our services at 703-778-6800 or online at www.ellisonv.org. Thank you for your time.